Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So, today, this is by request. I am going to do just a brief, quick court docket, not court pleadings or paperwork, but a court docket review for Mr. Tory Lanez. Let's hop on into it. So here I have pulled up Tory Lanez's appeal that was filed in the Second Appellate District Court in California. This hold on. There we go. That's the information that I'm needing. All right. So the notice of appeal was filed on August 10th, 2023. It was not received, so it goes from the criminal court to the appeals court. It takes a while. It's not something that the next day it will be accepted. No, it does take a while. So it was received by the appellate court on September 18th. With that being said, they did request an extension of time in order to get the files from the lower court. So anytime you file an appeal, and especially, well, it's not even in especially, especially, anytime you file an appeal, you have to transfer your dockets from one court to the next court. So that means any pleadings, motions, petitions, whatever the case may be, whatever was filed in the lower court has to now come to the appellate court. Any court transcripts, court reporter transcripts, anything dealing with that lower court has to be transferred to the appellate court. And so they do need time in order to get that information. They granted them that time on the 19th, and they say, hey, by let's see, what is that, October 10th, you must have everything submitted. They sent an email on let's see, also the 19th, just to the court reporters, just letting them know that the time was extended. Let's see. It shows that on October 3rd, a rejected motion for bail. So I'm assuming that Tory Lanez filed, oh, there it is right here. So this is what he filed. He filed a motion for bail pending the appeal. And it was rejected because it was missing bookmarks. Y'all, let me tell you something. When you're dealing in the appeals court, it is a certain format that your pleadings have to be. If they are missing anything within those boundaries, your stuff is going to be rejected. I'm just throwing that out there. Let's see. So the motion was filed, a proposed order was filed on the 26th, and the court heard that and they said, let's see, pending appeal, the defendant may apply to the reviewing court for bail pending appeal. The defendant must show he first sought relief in the superior court, and the superior court unjustifiably denied the application. So that pretty much means that if he filed a motion in the lower court and the lower court denied it for an unjustifiable reason, then they can take that into account and say, okay, we see that they denied your motion for bail, so we're going to go ahead and do this. But that wasn't the case. I don't believe that he filed a motion for bail in the lower court or the superior court. Let's see. Da, 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 da. Oh, this is deep. So I'm going to go ahead and read this, and this is the court's minutes. So the court is in receipt of appellant's motion for bail pending appeal pursuant to the Penal Code Section 1272.1 and California Rules of Court 8.32. I'm sorry, 312. Pending appeal, the defendant may apply to the reviewing court for bail pending appeal. The defendant must show he first sought relief in the superior court, and the superior court unjustifiably denied the application. Penal Code Section 1272.1 provides that release on bail pending appeal shall be ordered if the defendant demonstrates by clear and convincing evidence he is unlikely to flee, he does not pose a danger to the safety of any other persons or to the community, and the appeal is not for the purpose of delay in raising a substantial legal question which could result in reversal. Appellant has not shown that the Superior Court unjustifiably denied the relief. Although he has submitted the minute order denying his motion for bail on appeal in the trial court, he has not submitted the reporter's transcript of the hearing or other settled statements contained in the trial court's reasoning. So he did sought relief in the trial court, and he submitted some documents, but he did not submit the court reporter's transcript of that particular hearing. So, because y'all know the court reporter pretty much types everything that everybody is saying in the courtroom, and they failed to do that. Moreover, appellant concedes that the trial court denied his motion in part because he was convicted of a violent felony, namely assault with a semi-automatic pow pow. Let's see, with a finding that he caused great bodily injury. A true finding on Penal Code Section 12022.5, pow pow allegation renders the underlying crime a violent felony. Appellant notes that proposed legislation, Assembly Bill 1310, would make an enhancement under Penal Code Section 12022.5 legally invalid. However, as appellant also notes, the governor has not signed that bill into law, nor would passage of that law result in a reversal of his conviction, even if it resulted in a reduction in appellant's sentence. Therefore, appellant currently stands convicted of a violent felony, which is the factor a court shall consider in determining whether the defendant poses a danger to the community. Also, according to appellant, the trial court denied this motion because appellant is a Canadian citizen, which is a factor to consider in determining his likelihood of fleeing. Finally, the trial court denied the motion because it had to modify and increase bail during the proceedings below. This suggests that there were concerns about appellant being a potential flight risk. Therefore, based on this record, appellant has not shown the trial court unjustifiably denied relief or otherwise shown by clear and convincing evidence entitled to relief. So that's why he was not granted bail, because he is a likely a flight risk and he is likely to flee since he is a Canadian resident, and because of the crime under, the underlying crime or the alleged crime, it is a violent offense. Alrighty, now on, let's see, that is November 14th. They finally got all the documents from the trial court. So there were, clerk's transcripts. Now, this is just the clerk of court, not the court reporter, but the clerk transcripts. There were a total of 1,045 pages. There were 13 court reporter transcripts, one probation report, and 3 sealed transcripts. Let's see, on 12/19, time was requested, and I am trying to see who put that in. I am assuming that is it doesn't have anything, but I'm assuming that Meg Thee Stallion's attorney, see, they have to also do briefs. So once you file an appeal, you order all the court records and they have been transferred from the trial court to the appellate court. You then have to submit a brief. And what is a brief? I'll pull that up later. I'll pull that up in a second. Because I've done one and people call me now and ask me, do I do appellate briefs? And I'll be like, no, because that will drive you crazy. Anywho's, so I'm assuming that Meg's attorney put in a request to extend time to have the brief prepared and submitted. That time was granted on December 20th. Let's see. Now, I got these dates backwards. So, Oh no, I'll take that back. So a pro hoc vice application of Laura and Jose was filed, and it did not comply with whatever those California rules of procedure were. And what a pro hoc vice is, if you have watched my videos time and time again, I go over this. It is just where an attorney from another state will file a pro hoc application in order to practice law under that state's attorney. So for instance, Laura might be an attorney in Florida and she files a pro hoc vice application. And if she's approved, she gets to practice law up under well, not practice law, she gets to do this case. She gets to handle this case under a bar license, valid license attorney in California. So whatever they submitted, it was incorrect and they rejected that. Let's see, Appellate's opening brief. So oh no, that's just the opening brief that was submitted on February 26th. Let's see, they submitted another application on the 4th of March and it was granted on the 6th of March, which is awesome. All right, we come down to March 21st and it shows that a request for extension of time for the brief to be submitted, be extended. And they went ahead and said, okay, we're going to grant you that extension and it will be due on the 28th of May. Come the 21st of May, they filed another extension and they said, okay, it's going to be due on June 27th. Let's see. Now, Meg and them said, hey, y'all got a confidential transcript. We need a copy of that. So they filed a motion to get a copy of that. And then they said, okay, we need some more time to get this brief together. So they submitted another request for an extension of time on the 20th. Let's see. And then the day after, Tory Lanez's attorney filed a motion for relevant evidence, meaning that they have some new evidence or new discovery that they would like to bring forth. Now that is big, and I seen that going all over the internet about this new evidence. What now? We're not going to see this. This is considered discovery. Discovery is not available to the public unless the attorneys or the plaintiff and the defendant, agrees to say, okay, we can release that to the public. That's not something that we're going to see just yet, especially on these court dockets. So we're going to have to wait. So that motion was filed. And then they said, oh, now, since y'all done filed this new evidence, we need to know what that evidence is. So they said, we need we need some more time. So that time was granted on the 24th of June, making their brief due on July 29th. So it is July 18th. So we still have a couple of days before we see. Hopefully they will file it either before or on July 29th. Let's see. Now that motion to enter that evidence was actually granted on the 24th. So it says respondent's application. Oh, I take that back. Wait. Respondent's application for a copy of the confidential transcripts for the hearing held on December 21st is granted. Wait. Oh, this is Meg's. I'm thinking about the motion for evidence. So Megan and them filed an application or motion to get the confidential transcripts, and on June 24th, the court said, okay, you can have a copy of that sealed transcript, and the clerk has to provide that to the counsel either by email or giving them access to that sealed transcript. Let's see. Now, because Tory Lanez and them filed this motion to enter this evidence, Megan and them said, we oppose to that motion for discovery. Like, what are y'all trying to enter in there? Yeah, this is crazy. Then the court heard it. They said, hey, the court has read and considered the petitioner Daystar Peterson's June 21st, 2024 motion for relevant evidence brought pursuant to Penal Code Section 745, Subdivision D, and the People's June 26, 24 opposition to Peterson's motion for discovery. Good reasoning appearing, the motion for discovery will be considered together with Peterson's pending petition for writ of habeas corpus filed on December 12th, 2023. So, as of right now, what is going on is one, we are waiting on Meg and her attorneys to submit a their brief, and then two, I don't know if it has already happened yet, but I'm pretty sure they are behind the scenes reviewing whatever this new discovery is. And whatever it is, they're also applying it to I'm about to call him Peterson. I mean, that's his last name. To Trey Songs. To Tory Lanez. To Tory Lanez petition for writ of habeas corpus. So that's pretty much what is going on with this. It does not show anything about an appeal being granted. Right now, the responding party, Meg the Stallion, and her firm, they have not submitted an appeal. Not appeal. They haven't submitted their brief, so nothing can be decided until the other party has submitted their brief and they have an opportunity to both argue their sides. Okay, so no appeal has been granted. No appeal has been granted. The only thing we are waiting on is for Meg and them to get their appeal filed with the court. That appeal is due on the appeal brief is due on July 29th, 2024. And I know I keep saying appeal. Let me be clear. The brief. Meg and her team has to submit the brief by July 29th, 2024. And that's it. That is all. I wanted to show you guys what an appellate brief actually looks like, because like I said, it has to be drafted in a certain way. Let me see. Appellate appeal. Oop, there we go. I'm sorry, y'all. Okay, appeal, appellate brief. Bam. All right, I'm gonna share my screen right quick. Okay, let's see. All right, so this is one that I did out of Houston. But like I said, each appeals court has their own format. So you have to make sure that you do it a certain way, from the title pages to the table of content to the table of authorities. It has to be done a certain way. If anything is not, if missing, they're going to reject it. They're going to reject it. Now, for me, this is very time consuming. It's only 54 pages, but it's time consuming because there's a lot of information that you have to put in here. Once again, the purpose of an appeal is to have a higher court review the lower court's rulings. And if the losing party, I'm trying to work with the simplest terms. If the losing party finds issues in that ruling, they have to present those issues in this brief. So they find the issues, and then they have to back them up with, evidence. And that's why you see the motion for discovery, because there's new evidence that can be applied. You have to back it up by other cases and other statutes, so you have to make sure you put the table of authorities in there. So it's a lot of stuff that you have to do, and like, I can't put all of this together. Each page has to be something. So that's the statement of facts. Then we got the issues presented. Then we got, summary of the argument, all of this. And then I can't show that because that's the appendix. But yeah, so that's all. So to answer the question that was posed earlier, no, an appeal has not been granted. Meg and her law firm have to file a brief first and foremost, but I'm sure they're going to do that here in the next couple of days. They got the sealed transcripts that they requested. Whatever this new evidence is, I know that they have to work 10 times harder because I don't know if this evidence is favorable in Meg's case. So we shall see how this outcome plays. But other than that, tell me what you guys think about this video. Don't forget to like, share, and subscribe. Until then, be blessed.